and a ladder of extreme and outrageous conduct intentionally and recklessly inflicted by debtor Scott Lord to cause creditor Glendora emotional distress, and Scott Lord is liable for damages for the same. This conduct of debtor Scott Lord goes beyond all possible bounds of decency, is regarded as atrocious and utterly intolerable in a civilized community. These acts of debtor Scott Lord are malicious and wrongful, as are all of his attacks within the hallowed halls of the Westbury Bankruptcy Court, the judge is named Hall, which have gone on and which creditor Glendora has reported for 4 years. The effect of these attacks is to produce suffering and anxiety, and there is a guarantee of genuineness in the circumstances surrounding the stated mental disturbance, for such recovery is permitted. Has inflicted severe mental pain and anguish through this deliberate and malicious campaign of harassment and intimidation. His conduct has been extraordinarily vindictive. All of this gives rise to a tort cause of action for emotional distress. An action lies here, since debtor Scott Lord uttered these malicious words where they would produce and did produce damage. Creditor Glendora can recover exemplary damages in a common law action for intentional harm from mental disturbance and offense to her personal dignity resulting from these oral assaults and directly violent conduct. Point E, Scott Lord's conduct has been outrageous and shocking. Scott Lord's conduct was so outrageous and shocking as to exceed all bounds of decency as measured by what the average member of the community would tolerate. 2, debtor Scott Lord's conduct has caused severe mental distress to creditor Glendora. And 3, debtor Scott Lord has acted with the desire to cause such distress and acted recklessly and under circumstances that made it certain debtor knew that mental distress would result. Point F, Scott Lord and Bert Stutchen violate Glendora's First Amendment right to free speech. Big one. They're trying to gag these reports. This is very serious business, millions of dollars serious. Glendora has watched these cases in the United States District Court, Southern District of New York, and White Plains. Glendora can sue these two for this violation of civil rights. Point G, Glendora's privilege. She has sued Scott Lord. Both are litigants. By New York State CPLR, Glendora can say what she wants about Scott Lord. She is absolutely privileged. Judge Holden told me that. Point H, any papers that Glendora shows others about Scott Lord are public record. These papers are open to the public. They're at the district court, they're at the Office of Consumer Affairs, they're at the county clerk's office, they're at the sheriff's office, and they're at the district attorney's office in Nassau. No action can be taken against Glendora for talking about or writing about the public record. Any such action would be in violation of Glendora's First Amendment rights. Point I, Scott Lord has tried for years to quash his public and very bad record. In the summer of 1992, he tried to make a deal with Glendora to pay her $4,600 if she would stop her letter. Scott Lord said, I want my Consumer Affairs license, and Consumer Affairs says to talk to you. Glendora did not go for the deal. To stop the letters for $4,600 would be blackmail. Glendora kept up the letters. Now she has the television program. Point J, the instant motion is as bad, as unlikely, and as unreasonable as Scott Lord's motion to Judge Hall in 1991. You remember that? To vacate Scott Lord's numerous defaults. He must have defaulted about 21 times, and he expected the judge to vacate those. Well, the judge didn't. The judge was a year making his decision, and he denied such a motion to vacate his defaults. And in doing so, the judge said, Scott Lord's sinister attempts to manipulate the bankruptcy court. Well, folks, here's another such sinister attempt. Point K, subsequent to filing the proof of claim, Glendora Buell commenced a campaign to terrorize. This is a lie. The burden of proof is upon the debtor to come up with any evidence of same. Point L, on or about March 30th, 1993, Glendora commenced a lawsuit in Westchester County Supreme Court, and there's no telling. He says that he paid $6,000 in legal fees in connection with the defense and the creditor's frivolous claim. Well, I don't really understand what point Stutchen and Lord are trying to make there. I don't think anybody can. It's just not plain English. It's like ancient Swedish. Glendora wants to see the canceled check proving that Scott Lord paid the alleged $6,000 legal fees to Bert Stutchen. What is frivolous about Glendora's claim against a debtor, Scott Lord? Below is a lie. Glendora has, this is from Stutchen's and Lord's paper. Glendora has further admitted spending hundreds of hours stalking me at my house and place of business on dozens of occasions, videotaping me, my friends, my family, and my business associates without our consent. Glendora has not, never will stalk Scott Lord's house. She has never even seen the same. She has never admitted any such stalking, and the debtor has to show proof. Glendora has videotaped from the street Scott Lord's place of business to show Consumer Affairs that Scott Lord is operating the same old home improvement business without a home improvement license and thereby is in violation of Local Law 6, the very same crime he was arrested for in 1987, paid a $300 fine for, and for which he was put on probation for 3 years. Scott Lord is violating Glendora's freedom of speech. Said friends are unknown to Glendora. Said family are unknown to Glendora. Debtor's paranoia is pathetic. Debtor's hysteria is pathetic. Client Scott Lord and lawyer Bert Stutchen display ignorance below when they say, most recently Glendora has made 12 videotapes, at least 6 of which have been broadcast on public access cable television. Cable TV programs are cablecast, never broadcast. The cable signal goes through a cable, not over the air. Cable TV companies cannot broadcast. Broadcast TV stations cannot cablecast. And here is another lie. This is again quoted from their paper. It's not quoted, it's taken out and pasted. Wherein she narrates a summary of her efforts to annoy, intimidate, and harass me into satisfying the judgment. Well, that's stupid. Satisfy what judgment? The bankruptcy court has already satisfied the judgment through the excellent work of trustee Richard O'Connell. There is $19,400 in the creditor's bank account. So you see, it's satisfied. Further, creditor Glendora does not narrate any such thing. Creditor Glendora tells people how people like Scott Lord lie, steal, and cheat, what people can do to avoid being ripped off, and such is a great service to the public. Now he goes, Stutchen and Lord go on to say these broadcasts were libelous and included accusations that I am a liar, a chief, and a thief. Well, he's on record as being a liar, a thief, and a chief. It's not an accusation. Upon information and belief, these broadcasts reached an... Oh, let me go into that later. First of all, they are not broadcasts. We made that point. It is ignorant to say they are. Second, that Scott Lord is a liar, a cheat, and a thief is a matter of widespread public record. District Court, DA's office, Sheriff's office, County Clerk's office, Office of the Consumer Affairs. Third, it is ignorant to say several 100,000 persons, they put down here, have seen these programs in Nassau and Suffolk counties, New York City, and elsewhere. Well, first of all, they aren't on in Suffolk County. Cable TV programs, folks, locally cablecast, as this one is, such as A Chat with Glendora, do not show up in the ratings books. Nobody knows how many people are watching. A cable company like TCI will tell you, oh, we pass 87,000 homes. But nobody ever knows how many people at a given moment are watching a given channel. That just doesn't show up in the ratings books. The spots that Glendora ordered for Scott Lord on WCBS TV Channel 2 would have been seen, if he hadn't lied, stolen, and cheated, by 100,000 viewers. That type of TV does show up in the ratings books, so you know what you're dealing with. And including the county in which I reside and counties in which I do business. Well, what counties are these? And does Scott Lord have a home improvement license authorizing him to do business? And further, they write, on or about March 1993, Glendora telephoned my residence, as she does on a regular basis, and accosted my 16-year-old son. I don't even know his 6-year-old son. I never telephoned his residence. I never talked to his son. She told him that his father is nothing but a liar and a cheat. That is not so. That's a lie. That he was intentionally left out of his grandfather's will. That's a lie. And that she hoped he would not turn out to be like his father. That is a lie. So the burden of proof is on Scott Lord to prove this. This is hearsay. For one thing, it's hearsay. It's not accepted in the court because it's not something that Scott Lord witnessed or Bert Stutchen witnessed. This is hearsay. This is a lie. Glendora never did any such thing. Let debtor show proof. The burden of proof is on the debtor. This is hearsay. Scott Lord can never prove this. It never happened. Stutchin should be ashamed to act as an attorney for such an insane statement. Phone my business associates and competitors on a regular basis as well, and circulates to them copies of old police reports against me, copies of paid judgments, or many copies of unpaid judgments, pending lawsuits and other documents aimed at discrediting me and the debtor corporation. That's not what they're aimed at. They're aimed at information. Now, whatever Glendora has said to anybody, anywhere about Scott Lord is a public record. Scott Lord violates Glendora's First Amendment right to free speech. This is dangerous business. If any business has been lost, as alleged here, what lost the business is the ripping off by Scott Lord and others. They are the ones who lost any such business as alleged. The ripping off of scores of people by the crime feasors is what lost, quote, unquote, any such business as alleged. It's not the reports that lost it. It's the record of Scott Lord that lost it. I estimate that my employer has lost, and that would be Tri-State Irrigation, Jan Stahl and Jeffrey Burns, has lost in excess of $10,000 in revenues as a proximate cause of Glendora's interference with these contractual relations. I did not interfere with the contractual relations. Such were lost again. Then it was the business practice of the accuser that did it. Who wants to do business with a person who has scores of judgments against him in the public record? On with this one. Approximately 30 past customers have refused to continue to have service calls performed by my employer, citing the negative publicity generated by Glendora. Proof is requested. This is hearsay. Where are the affidavits of said 30 past customers? Glendora's monthly mailings contain numerous false, misleading, and libelous statements, including suggesting that the Nassau County Department of Consumer Affairs has permanently barred me from being issued a license, that there are dozens of unpaid judgments against me, that I never pay my attorney's fees, etc. Well, all you have to do is read the letter of what Consumer Affairs has written about Scott Lord to Scott Lord, a letter that is on file in that office. All you have to do is see the public record on unpaid judgments open to the public. It is libel and slander only when it is not true. All that Glendora has published is public record. I have paid a retainer fee of an additional $3,500, Scott Lord writes, for legal fees incurred and to be incurred in connection with the instant motion. It would have been far better not to have made this motion. It is inadvisable to waste the court's time, and debtor and lawyer should be sanctioned for this drivel. My attorney advises me that Title 11, USC 362H, was enacted to prevent the kind of campaign of harassment, intimidation, and annoyance that Glendora has waged. This has not been a campaign of any such dimension. This has been a campaign to inform the public how to watch out for fraud, and how to deal with fraud, and how to stand up for their rights. Glendora has never violated the automatic stay. The default judgment has been ably collected by the bankruptcy court through the brilliant work of Richard O'Connell. This statement by the debtor and his ghostwriter, attorney Bert Stutchin, shows no intelligence and no common sense. Her course of conduct amply demonstrates her utter and total disregard of the automatic stay. This is a lie. The court should not countenance her continued abusive conduct and her trampling of the debtor's right. The debtor cannot violate Glendora's right to free speech by the United States mail nor by television. Scott Lord, he's the movant. And ghostwriter, that would be Stutchin, the lawyer, asked the court to sanction Glendora for a lie that the movement and the lawyer are telling. Movement and lawyer did not number their pages, so one cannot refer to pages by number. Scott Lord's signature has undergone another metamorphosis. Glendora has been seeing his signature change several times since 1986. One time, Scott Lord gave his name over the telephone as Scott Ward. The notary for Scott Lord's affidavit is his ghostwriter. Debtor and lawyer failed to send their motion to creditor's designated address. The designated address is Box 532, Scarsdale, New York, 10583, and always has been. It is ignorance to send the motion to any but the designated address. The Christmas lights are coming down. They should. This is Epiphany. Henceforth, all papers sent to any but the designated address will be refused and returned unopened and be on notice. Res judicata, collateral estoppel, Scott Lord and Bert Stutchen tried this very same action before Judge Samuel Fredman in Westchester Supreme Court. Lord, Barnes and Stahl made counterclaims stating this very same drivel, and nothing ever came of it. Glendora did not make Scott Lord's bad record. Scott, and Scott alone, did that. Scott committed a crime, a fraudulent conveyance, along with Jan Stahl and Jeffrey Barnes. All three have been convicted and have been paid the fine for the same. And then after this comes in, next couple of days, in comes another one, correcting many of the errors in the first one. So I titled this one, Can't Get It Right the First Time. How many more affidavits are we going to get and sent to the wrong address? Tri-State Irrigation, what is their address? Tri-State Irrigation is no longer at 13 Center Street. 13 Center Street is vacant. There is no Tri-State Irrigation Systems, nor any Atlantis lawn sprinkler systems at 13 Center Street. Mysteriously, like Arabs in the night, Tri-State Irrigation System simply disappeared and never notified the Nassau County Department of Consumer Affairs. Tri-State broke the rules. And one door away in the same building at 17 Center Street, right under the nose of the Hempstead District Court, Scott Lord is illegally operating a business, Forever Green Atlantis Lawn Sprinkler Group, Shades of the Past, with no license from Consumer Affairs. The same breaking of Local Law 6 for which a warrant was issued in 1987 for his arrest, and for which Scott Lord paid a $300 penalty and did 3 years of probation. Now, how is that for lying, stealing, and cheating? My attorney has advised me that I am seeking a broad interpretation of 362H vis-a-vis Chapter 7 case because the debtor corporation is out of business and, of course, did not itself lose its customer base. Yeah. A liar has to have an excellent memory, folks. It is hard to keep the lies straight. You have to remember what lie you told. However, Scott Lord writes, as the sole officer, director, and stockholder of the debtor corporation, the actions of Glendora against me personally were made in an effort to coerce payment of the corporation's judgment. The court should not countenance her actions, even though they were directed primarily against me personally, rather than against the debtor corporation. Well, a wiser man than Scott Lord and his ghostwriter, Bert Stutchen, ruled a long time ago that this was not an issue. From the start, January 1990, Trustee Richard O'Connell had no problem with Scott Lord's attempt to hide behind the corporate shield. From the start, everybody knew about the alter ego sham. Now he writes, I am advised that if this were a Chapter 11 case, there is ample legal authority for providing protection to the corporate principals where the improper actions of the creditor are impending the effective reorganization of the corporate debtor. Do you understand that? Well, don't bother. First, this is not a Chapter 11, although this may be by Scott's next bankruptcy. He has gone bankrupt in Chapter 13 and 2 Chapter 7s. This is his third bankruptcy, back to back. Secondly, there will be no more Atlantis Lawn Sprinklers Company Incorporated. In a few more weeks, it will be dissolved. It will be gone forever. You know that, folks, don't you? That in a Chapter 7 corporate bankruptcy, there's no discharge. If an individual goes bankrupt, there is a discharge. But in a Chapter 7 corporate, there is no discharge. What happens is that the corporation is dissolved and it's never heard of again. Thirdly, again, Glendora did not have to collect the judgment. The trustee already has done that for her. Okay. To afford me, Scott Lord, protection from the malicious, libelous, wrongful, and tortious action of Glendora. Malicious? Who called Glendora in October 1993 and said, I hear your case got kicked out of Supreme Court? Who telephoned Glendora and said, I'll get even with you? Who called Glendora in December of 1993 and said, you aren't going to get any money, my lawyer put a stop to it? On audio tape it tells who. Libelous is only when it is a lie. Glendora told the truth. What Glendora told is a matter of public record. Glendora never committed a tort. Scott Lord, as a matter of fact and record, has committed legions. Glendora acted as an investigative reporter. She filled out the Freedom of Information forms. She used the records offices of the public agencies. She publicized the record on paper and on television. Scott Lord and ghostwriter Bert Stutchen are violating another constitutional right, freedom of the press. The public has a right to know what Scott Lord perpetrated, to protect itself against people like Scott Lord. Glendora cross-moves that Scott Lord and attorney Bert Stutchen be sanctioned for wasting the court's time with his frivolous and trivial drivel, 2 envelopes full of it. The second envelope had numbered pages. What will the third supplemental affidavit have? Now, this is a big point, and you've probably seen this all along. The bankruptcy court reduced the $54,000 judgment against Scott Lord for fraudulent conveyances and allowed the same debtor time payments on the basis he did not have the wherewithal. Yet debtor can find all these thousands to pay lawyers, and these thousands should have gone to the creditors. In addition to paying Stutchen, Scott Lord paid Janowitz and Rothenberg. One lawyer Scott Lord did not pay is bankruptcy judge Dorothy Eisenberg. The Eisenberg action is on file in Hempstead District Court. Eisenberg was Scott Lord's lawyer in his Chapter 13 bankruptcy in 1985, and Scott Lord did not pay her, and so she sued him, and then she ends up being a bankruptcy judge right next to Judge Hall in the Eastern District on Bravado Road in Westbury. Now, here's another big point. Glendora can still press for a criminal investigation of Scott Lord, Jan Stahl, and Jeffrey Barnes. This has not been typewritten, but I have written it out, and it will be typewritten sometime today, I hope, which is January 13, 1994, Thursday. The motion by debtor Scott Lord must be dismissed pursuant to Federal Civil Rules and Procedure, Rule 12B6. The debtor fails to state a claim upon which relief can be granted. Glendora did not violate the automatic stay. The burden of proof is upon the movement, that would be Scott Lord, to prove his claim, and he has failed to prove his case. Now, another point. In the interest of getting this protracted, agonizing bankruptcy closed, which was started January the 30th, 1990, and is about to have its 4th birthday, this motion by debtor Scott Lord should be summarily dismissed. Now here's the recapitulation in the conclusion. The motion should be dismissed because 1, Glendora did not violate the automatic stay. 2, Glendora is privileged. 3, everything that Glendora said was a public record. 4, it is paranoia and hysteria. 5, the judgment is satisfied. $19,400 is in the creditor's bank account. It is based on hearsay. Any business lost is due to Scott Lord's bad record, not to Glendora. It is frivolous. It is a waste of the court's time. And it is res judicata. And it is libelous only when it tells a lie, and everything Glendora has said has told the truth. And for in the last point, it should be dismissed because it fails to state a claim upon which relief can be granted. Glendora's counterclaim should be granted on the grounds that Scott Lord is violating her First Amendment right to freedom of speech, and Scott Lord has committed against Glendora the tort of emotional disturbance, willfully inflicted. So Glendora cross-moves to dismiss the debtor's motion of December the 21st, 1993, to sanction debtor Scott Lord and attorney Bert H. Stutchen in the amount of $20,000 payable to Glendora, and award Glendora such other relief as this court deems just and fair. And then we will sign that, date that well, after it's typed and ready to go and the master is made. And then we will sign at Glendora because it's an affidavit, and then you have to have a jurat. You know what a jurat is? Subscribed and sworn to before me this blank day of blank month, 1990 blank, and then that's where the notary public puts the name in. You know, most lawyers, they're in a hurry and they do things sloppy. They'll just say sworn to before me. But if you go for a good notary public, the notary public will say subscribed and sworn to before me. Subscribed means that you were there and you wrote down your name. Subscribed and sworn to. So folks, this is what happened on Glendora versus Scott Lord on the week of January the 3rd, the first week of the new year, 1994. And Bob says that the boss has an even disposition, and Charlie says right is rotten all of the time. And Marilyn says I never have to worry about the boss losing his temper. He can always find it when he needs it. Take care. Stand up for your rights and don't let people rip you off. Katie. Katie cat. Katie cat. This is mailing number 186, Glendora versus Gannett Broder et al. What happened on January the 3rd, 1994 week. Monday, Glendora had to go to the federal courthouse for something else and looked in on the courtrooms. Judge Bryan had a fascinating trial going on age discrimination, Devonshire Tire versus Caruso, or the other way around, Caruso versus Devonshire Tire. Judge Fox was using Judge Broderick's courtroom. The jury was deliberating and handing its decision to the clerk sitting outside the jury room door. Judge could tell the courtroom was dark. Judge Schwartzberg is away in Boston. There was no time today to work on Broder. And the dividend came, and the Gannett stock is paying 33 cents a share. January the 4th, 1994, Tuesday, our appointment to meet the New York Giants for the latest in sports medicine at Giant Stadium was postponed because of 6 inches of snow. And GCI was going for 55 3/4. January the 5th, 1994, Wednesday, Glendora worked an hour getting the Broder mailing ready. January 6th was editing day at TCI Cable. Glendora edited Broder chapter 56 and 57. Took a long time, maybe an hour and a half. Callaghan motion to dismiss Glendora's cross motion to dismiss his motion and to award Glendora $600,000. An hour and a half. The 7th, Friday, no time for Broder. Broder had an article in the newspaper today. There has been nothing since. November the 8th, no, he had that article in the newspaper on the 3rd, Monday. January the 8th, Saturday, no time for Broder. January the 9th, Sunday, the Broder mailing got out. It is a mess. The copy cost $7. The postage was $6. The time was 2 hours. And the total time on Broder this week is 7 hours. And Broder files are up to volume 43, and some of them have been taken down to the basement storage bin. And Marilyn says, why do you take your paycheck to the bank? And Evelyn says, because it's too little to go by itself. This is Glendora versus Gannett Broder et al. And this is what happened the week of January the 3rd, the first week of 1994. Keep your courage flaming. Here's what happened on Glendora versus the DHCR, the New York State Division of Housing and Community Renewal, and versus the William Street DHCR down in Manhattan, and Judge Coppola. The week of January the 3rd, 1994, the first week of the new year. Glendora has 6 months to perfect the Coppola appeal and the Coppola 2 appeal. There's going to be 2 appeals against Coppola. On the Fredman appeal, she is up to the statement of facts. The listing of the points is done, 23 of them. Franklin took more videotapes to Yonkers Cablevision and picked up the ones that had been cablecast, Chapter 9, Chapter 8, DHCR, William Street and Cupola were handed in. Glendora will have to try to get out a mailing this week on the DHCR. The time on the DHCR this week is a quarter of an hour. Monday, January 3rd, Tuesday, January 4th, and Wednesday, January 5th. That was a quarter of an hour. And the Electoral College folks would do a lot better if they had a football team. Now, on January 6th, Thursday, we added videotapes update, and we did the DHCR on William Street and Cupola. And on January the 7th, 94, Friday, 4 half-hour programs on the DHCR William Street, Cupola are ready to go to Manhattan, and they did go to Manhattan to be cablecast. The William Street people can see them. January the 8th, 94, Saturday, no time for DHCR. On the 9th, Sunday, this log is ready to go out tomorrow, and the cost to print will be $18 and to post will be $7. And the time on DHCR this week is 1¼ hours. And Marilyn says, how come you take your paycheck to the bank every week? And Joanne says, because it's too little to go by itself. Take care, folks. Glendora versus Lydia Gallicano et al. On the week of January the 3rd, 1994, the first week of the new year. Jeannie can tell you. There's Jeannie. Jeannie's right here to tell you. We got out a log, and on Monday, we edited quite a few Lydia chapters. I think we're up to chapter 8, half-hour chapters. And these have been edited, and the VHSs, I believe, are made, and they are ready to distribute. And they're going all over the place. They're going to Manhattan, and they're going to White Plains, and to TCI, and to Cablevision Harrison, and Cablevision Yonkers, and Continental Cablevision. They're going all over the place. And here's a letter that I wrote to the appellate division. This appeal was perfected November 16, 1993, Glendora, plaintiff appellant against Lydia Gallicano and Larry Gallicano. Defendants, respondents. The defendants and the respondents have not submitted a respondent's brief in 30 days, nay, in 6 weeks. Appellant Glendora requests that the court not accept a respondent's brief should one ever happen to come in. It is now too late for respondents to submit a brief. White Plains, New York, dated January 3rd, 1994, yours in truth, Glendora. For editing Lydia, those 5 programs that I told you about in the VHS, that would be $165. So that's it, and I told you that we got out the mailing, and that the videotaping and the editing are moving along. It's a very, very long project. I wonder how many more chapters it's going to be. We covered the cellar, the exterminator, the butchery of the greenery, the cellar stairway. We spent 7 hours on Lydia this week. And Marilyn says, why do you take your paycheck to the bank every week? And Evelyn says, because it's too little to go by itself. This is Glendora versus Lydia Gallicano et al. What happened on the first week of the year, 1994. Keep your courage flaming. Number 45, January 3rd, 1994 week, Glendora versus Walsh, Alpucci, and Larkin. What happened at 21 Greenwich Avenue? Monday, Glendora was in county courthouse and asked to see defendant's Bendich affidavit of service, or to the so-called answer. She found a paper Bendich should have sent her. If you send it to the court, you have to send it to the plaintiff. It was his nunc pro tunc. And I had to fight to get that. I had to fight and ask the secretary, Ms. Hopkins, and then I had to fight and ask Mr. Santucci, the law clerk. And this is the thing that Bendich should have sent me. And I called Bendich on the phone and I asked him to send it to me, and he wouldn't cooperate. Honorable W. Dennis Donovan, Justice Supreme Court, Westchester County Courthouse, 111 Grove Street, White Plains, New York, 10601. Re. Glendora versus Walsh et al., index number 2048293. Dear Judge Donovan, Mr. Sanducci has advised me that this matter was calendared for December 17, 1993. Plaintiff pro se had filed an affidavit in vehement opposition in addition to a motion for default. Since CPLR 2103 was complied with, I would request that my enclosed affidavit be considered nunc pro tunc. Nunc pro tunc is do it fast. But you see, that's not right. The Bendich never sent me a copy of that. I didn't know that this was going on. He shouldn't talk to the judge and not tell me about it. And nunc pro tunc shows that, like all of his papers, he's mishandled it entirely. And I had to fight to get these affidavits of service, a copy of these affidavits of service of the so-called answer to my motion, to my complaint. And then I had to fight to get this affidavit of service for this nunc pro tunc letter. All right. He should have sent that to Glendora. It was with his screwy one-page affidavit. She also saw his affidavit of service for that, which was after the return date. And what a messy job Bendich did. Nella Alpucci called TCI last Tuesday night and said she would sue them for libel and slander. That is ridiculous. Libel and slander mean that lies were told, and everything told here is the truth. Libel and slander are hard enough to win when the truth is being told. You cannot win them on Nella's lies. Glendora talked to Lieutenant Quinn and asked him why Eric Fisher called TCI. All of this violates the First Amendment right to free speech. John Porzio had a door closer put on the outside cellar door. It is nice. Glendora talked to Porzio at length. Caesar does everything so well, folks. He can do anything, he can do everything, and everything he does is done well. And it's done beautifully. The Electoral College would be better off if they had a football team. Glendora asked Bendich to send her a copy of his nunc pro tunc letter to Donovan. Glendora should have got it without having to ask. He also asked for a copy of the two affidavits of service. Glendora asked for those. Bendich would not comply. Tuesday night at 9 p.m., Glendora versus Walsh, Alpucci, and Larkin was on TV, Chapter 27, Program number 1357, What Happened in September 1993. There was only one call. It was just a half ring. Somebody thought better of it. The time on wall this week is 2 hours so far, and on Wednesday somebody slapped the window pane of Glendora's south bedroom window. It would have to be somebody tall enough to reach it. It was probably an Alpucci, and that's harassment number 562. Tortious act. Monday morning, Franklin delivered the wall log. One was returned 2D. Do you know the difference between a Xerox machine and the flu? A Xerox machine makes facsimiles, and the flu makes sick families. The consensus is that Sergeant Fitzsimmons does not have to be on the mailing list any longer. Thursday, Glendora had TCI cable TV here to fix her channel 16 so she could see the wall videotapes on television on the White Plains channel. Wouldn't you know that Budinsky, Candy Alpucci, grabbed the cable TV repairman and intruded. She wanted to know if her cable TV was being disconnected. Maybe she was worried because she called up TCI and told him that she was going to sue them. He told her he was here to see Glendora. Well, that's good. Remember how Daniel Walsh intruded whenever Glendora summoned the police and when eyewitness news came? Glendora has a right to have people come to her home without Walsh and Alpucci intruding. There is some privacy left in this world, isn't there? Mr. Santucci said he would have a copy of the two Bendich affidavits of service and of the nunc pro tunc letter at the court clerks. I just think that's terrible that Bendich didn't have that served on me. To fix a radiator so we'll have more heat. There was too much winter this week, snow, ice, and wind, and the wall chapter was televised in northern Westchester Saturday morning, and a comment from up there was, that's too bad. Somebody called from Manhattan also and commented on it. This was a different chapter. This person asked for a Glendora Happy Book. There have been about 10 aggravated harassment calls this week, silence and hang up. Wall videotaping, editing are up to date. Distribution of programs to cable companies is almost up to date. Telecasting is about half over. And from Westchester Supreme Court, we await Judge Donovan's decision. Peter, I used to be miserable and depressed, but I turned all that around in the past year. Now I'm depressed and miserable. The time on wall this week is 2 hours. If things are as good next week as they have been this week, there will not be a What Happened log sent out next week. A Chat with Glendora is on television 31 times this month. Each is a half-hour program, and each one is different, and is telecast once and only once. And just this letter to Bruce Bendish asking you for that copy of those things. I bet you he won't send them. And a letter to Judge Donovan about your clerk, Mr. Santucci, was rude to Glendora. He insulted her efforts to keep the court informed by sending the court the weekly What Happened logs. A court should have as much information as it can get. Said What Happened logs go to the defendants and the lawyer every week. Mr. Santucci hung up on Glendora. Glendora has the whole conversation on audio tape and will discuss it on TV. Mr. Santucci should remain apart from the decision. This lawsuit has cost Glendora $250. She entitled to common courtesy. If Mr. Santucci does not want the weekly What Happened logs, then discard them. But Mr. Santucci should not violate Glendora's First Amendment right to free speech. Yours in truth, Glendora. And that's what happened. Oh, just one more thing. What started this? You got to go back to the beginning, and you got to remember what started this. The breaking of the law by the Walsh, Alpucci, and Larkin families. The White Plains Noise Ordinance, April 11th, 1993, Easter. Yelling, shouting, hooting, whistling, or singing at any time or place so as to annoy or disturb the quiet, comfort, repose, health, or peace of persons in any dwelling or other residence. That is the law that was broken initially. And when Glendora stood up for her rights and began videotaping her evidence, instead of reforming, these people started a long campaign of retaliation, more law-breaking, harassment, vandalism, thievery, abusive and insulting language, horn-blowing, fright, mental disturbance, and littering. You take care, folks. This is a Chat with Glendora, and keep your courage flaming. What happened on Glendora versus Russell Brower on January 3rd, 1994, the first Monday of the new year. I made an oral demand for the payment. That would be $250 plus the court fee for $5.58. Unfortunately, the court forgot to add another $2.58, which make it $8.16, because a second service of the summons had to be done. So we don't know what we're going to do about that. And so a man answered, and he had sort of a guttural voice, and whether it was really true and he had a cold or whether it was just put on. And so when I made the demand, he said, I'm going to appeal it. I asked if he were Russell Brower, and I never got an answer. And so I pointed out to him that to appeal it, that the cost of the minutes alone would be way over $300. And so then I left a message. No, I didn't leave a message. But at 10 p.m. That night, there was a message left on my recorder, and it said, this is Russell Brower, and I'm going to pay it, but I'm going to pay $10 every other month. Do you realize how long that would take? You know, they'd take 2 or 3 years. And without asking me if he could do it that way or anything, he's just up and going to do it that way. So on the 5th of January, which was Wednesday, I left a message on his recorder that that was an unacceptable arrangement, and that I wanted my payment all at once, and I wanted it in 30 days. And that the process was a transcript judgment, which cost $5. And then I would go to the Westchester County Clerk and have it entered. That would cost $10. Then I would ask for an execution. That would cost $5. Then I would go to the sheriff, and the sheriff would collect it. And then the sheriff would add his fees. That would be about $10.23. I believe it is in Yonkers. It is in White Plains, so it must be in Yonkers. And that if he refused to do all this, that we would have an information subpoena, and he would have to answer questions as to his assets and as to his bank account in the Department of Motor Vehicles. And that night, at 8:10 p.m., the telephone rang, and I said, good evening, 9495, and this abusive voice started. So I hung up, and so the telephone rang again, and Russell Brower, and Franklin answered, and Russell Brower got very insulting, and he used insulting words, and he said that he was going to tell his attorney. Well, I don't know what effect that's going to have, knowing what I think of attorneys. And he never had an attorney. I don't know if he has one. He said that he was going to have an attorney at the trial, but he didn't. He said he was going to do it that way, that he'd written a letter to the court. Well, what difference does that make? The court really doesn't care at this point. And that he said to stop harassing him, and no, he hadn't been harassed. And he says, I'm reporting you to the Better Business Bureau. He says, I'm a musician and I don't have money. Well, this is on audio tape 521. That I suspected all along was his problem. He didn't have the money, and he spoke as if he did. It would have been good for him to own up to that in the beginning. And so I took the insults long enough, and I told him that he was going to pay all at once, and he was going to do it in 30 days, and the sheriff was coming after him. And that is where it stands. Now, on I guess that's it. Okay. That's it for what happened on the week of January the 3rd, the first week of 1994. And this is Glendora versus Russell Brower. You take care and keep the courage flaming. The United States District Court, the Southern District of New York, Glendora Plaintiff versus Cablevision Systems Corporation, Charles F. Dolan, William J. Bell, Mark A. Liskotton, Francis F. Randolph Jr., John Tata, James A. Kofalt, Joseph Aznara, Thomas Garger, and William Quinn defendants. Notice of motion for a default judgment for defendant's failure to answer the summons and complaint previously filed in this matter. Honorable Charles L. Bryant, Jr. The answer due in the plaintiff's hands January 3rd, 1994, Monday, was never served. Plaintiff received no answer from defendants. The defendants did not make the 20-day appearance stated in the plaintiff's summons with notice. Please take notice that the plaintiff will move this court at the courthouse, 101 East Post Road, White Plains, New York, 10601, on the 24th day of January, 1994, at 9:30 a.m. of that day, or as soon thereafter as plaintiff can be heard, for an order for a default judgment for defendants, excepting William J. Bell, failure to answer the summons and complaint previously filed in this matter, and for the cost of this action and for what further relief this court deems just and proper. Dated White Plains, New York, January 7th, 1994. Yours in truth, Glendora. Glendora TV ads, a chat with Glendora, Box 416, White Plains, New York, 10602, 914-949-9495. And here's a list of people it goes to. That's all of the defendants, and they have no lawyer. So that's all of the people it goes to. And here is the motion itself and its affidavit. Glendora, being duly sworn, deposes and says that her reasons for motioning this court for a default judgment for defendant's failure to answer the summons and complaint previously filed in this matter follow. The answer due in the plaintiff's hands January 3rd, 1994 was never served. The plaintiff received no answer from the defendants. The defendants did not make the 20-day appearance stated in the plaintiff's summons with notice. This motion for default judgment does not apply to William J. Bell. There are two people in Nassau County with the name William J. Bell, and the wrong William J. Bell was served December 6, 1993. The right William J. Bell was served December 27, 1994. We rang the wrong bell. The summons with notice and complaint were served by certified mail, return receipt requested on all defendants December 6, 1993. Not counting the day of service and allowing over 5 days for service by mail, the time was up January 3rd, 1994. Each defendant was served with Form 18A, notice and acknowledgement of receipt of summons with complaint. Not one defendant signed the same and returned to Glendora. Every return receipt requested was returned as exhibited herein, with the exception of Charles Dolan, and he failed to claim the summons with notice and complaint. Further, in this time, the defendants have not cured the complaints and have not communicated with the plaintiff about these complaints. And for every reason, 3 to 15 of plaintiff's complaint served December 6, 1993. Accordingly, the above paragraphs 1 to 7 state a cause of action, and as a matter of law, the plaintiff should be granted her motion for a default judgment for defendant's failure to answer the summons and complaint previously filed in this matter plus the cost of this action, plus whatever further relief this court deems just and proper. Yours in truth, Glendora. Chat with Glendora. Box 416, White Plains, New York, 10602, 914-949-9495. Subscribed and sworn to before me the 7th day of January, 1994, Ivan Pinero. And here are all of the return receipts requested. And this is a default on a $31 million lawsuit. The damages on this lawsuit are $31 million for violating plaintiffs' freedom of speech, First Amendment rights. And they're down in the corner. That certified is to William J. Bell, and his came back also. These are the receipts, certified receipts. Costs plenty of money to send out one of these. Must cost about $25 for postage. Here's the one from Charles Dolan. Do you notice now that they served it on him 3 times? Okay, here they are, 12/18. That's 3 of them, 12/15, and then finally the yellow certified mail receipt came back to the post office and to me. And here's Franklin's affidavit of service, and he went to submit that to the United States District Court on Friday, January 7th, but the court was closed. The court was closed at 2 p.m. because of the weather. What a bunch of sissies, huh? And so this is his affidavit of service by mail. And that's what happened on Glendora versus Cablevision, Nassau County. And here is a joke. Bob is very arrogant, and his mother-in-law says that he brags that he's listed in Who's Through. Who's Through in America. Not Who's Who in America, but Who's Through in America. And the boss says that for 80 years he put his nose to the grindstone, and the secretary said, really? Gee, it must have been a beaut when he started out. Says that they named a town in Massachusetts after him. His mother-in-law says, yes, it's Marblehead. You take care, everybody. Here, the return date on this motion for default judgment is January 3rd, Monday. And we get interrogatories from this lawyer Purvis from Modern Courts. That's 1 page, and that is 2. And it really should be ignored because it's too late, but Supreme Court of the State of New York, Westchester County, Glendora, the plaintiff, versus Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and the Fund for Modern Courts defendants. Plaintiff Glendora's statement on defendant's interrogatory sent after the return date, which is ridiculous. Affidavit. Glendora, being duly sworn, deposes and says that defendants are far too late with their interrogatories when the return date for Glendora's motion for default judgment was January 3rd, 1994, Monday. Out of honor and honesty and good citizenship unknown to defendants and their lawyer, Glendora will answer the interrogatories, and she will read them on TV. The contract was oral. New York State adheres to the majority view that a contract need not be written. A contract spoken, an oral contract, is as valid and as viable as a written contract. A contract in New York State can be made either by words or by actions. Either by words or by actions. Defendants made the contract by words and by actions. This is incontrovertible. This lawsuit is not about a contract. It is about the defendants' negligences, all 23 negligences. They have a hard time remembering that, don't they? They want to run away. This lawyer knows defendants have no defense against these negligences and is trying to obfuscate the issue with talk about contract. This lawyer is trying to distract the judge and his law clerk. Now, the terms of the contract were Glendora would monitor the courts, write her reports, and defendants would publish a report of this monitoring and circulate the said report, all in the name of court reform in which all litigants had and have a common interest. This contract was made by all 4 defendants. All 4 were parties to the contract. As stated in this paper was read to you also. Plaintiff's affirmation in vehement opposition to defendant's so-called answer received by plaintiff too late, and plaintiff's affirmation in opposition to defendant's affirmation opposing plaintiff's motion for default judgment. The offer was made by the defendants. Plaintiff accepted the offer. Defendants breached the contract, and plaintiff is damaged to the extent of $20,000. The dates